I'll never forget the day Margaret Thompson walked into my courtroom. She was 73 years old, trembling, holding a stack of collection letters in her weathered hands. Margaret had been paying $200 every month to a credit card company for a debt that was over 8 years old. She didn't know that in her state that debt was legally unenforceable. She had drained nearly $20. Mosey saw zero from her fixed Social Security income, paying something the law no longer required her to pay. When I explained this to her, she broke down in tears, not tears of sadness, but relief. That money could have paid for her medications, her groceries, her dignity. I'm Judge Patricia Williams, and I spent nearly 32 years on the bench protecting the rights of seniors like Margaret. I've seen thousands of cases where elderly Americans were bullied, manipulated, and frightened into paying bills they had absolutely no legal obligation to pay. Today, I'm going to share with you 7 specific types of bills that you, as a senior, are not legally required to pay. These aren't loopholes or tricks. These are your rights under federal and state law. This information could save you thousands, maybe tens of thousands of dollars. I'm going to walk you through each bill type, explain the legal protection you have, share real stories from my courtroom, and give you the exact words to use when creditors come calling. We'll cover time-barred credit card debt, inflated medical bills you can negotiate, deficiency balances after home foreclosure, gym memberships you never properly canceled, illegal utility deposits, debts from a deceased spouse, and magazine subscriptions you didn't authorize. Before we begin, I need you to do something important. If this information helps you, click that like button. Share this with every senior you know, because financial predators are counting on older Americans not knowing their rights. Comment below and tell me which of these bills has been weighing on you. Your engagement helps this message reach more people who desperately need to hear it. Now, let's talk about the first bill you might not have to pay, and it's probably the most common one affecting seniors across America. Time-barred credit card debt. This is debt that's so old, the statute of limitations has expired. In most states, creditors have between 3 to 6 years to sue you for unpaid credit card debt. After that time passes, the debt becomes legally unenforceable. They can't take you to court, they can't garnish your wages, they can't seize your assets, but here's what they can do. And they do it constantly. They can still call you, they can still send threatening letters. They can still make you believe you're legally obligated to pay. Robert Jenkins was 68 when collectors started calling him about a Visa card he'd stopped paying in 2015. It was now 2023. 8 years had passed. In his state of Florida, the statute of limitations on credit card debt is 5 years. That debt was legally dead. But the collection agency never told him that. They called him 3 times a week. They sent letters with urgent red stamps. They told him his credit would be destroyed forever, that he could face legal action, that it was his moral duty to pay. Robert was terrified. He set up a payment plan for $150 a month on a $4 $300 debt. He made payments for 7 months before his daughter, who's a paralegal, discovered what was happening. She knew the law. That debt was a time barred. Robert didn't owe a single penny. Those collectors were counting on his fear and his sense of responsibility. Here's what you need to know about time-barred debt. First, find out your state's statute of limitations. You can search online for Statute of Limitations Credit Card Debt, plus your state name. Write down that number. Second, calculate when you made your last payment on the debt, not when you were contacted about it, but when you actually last paid. If more time has passed than your state's statute of limitations, that debt is likely time-barred. Third, and this is critical, do not make any payment, not even a single dollar, on a time-barred debt. Why? Because in most states, making a payment can restart the clock. That old dead debt suddenly comes back to life with a fresh statute of limitations. The collectors know this. That's why they pressure you to just pay something, anything, to show good faith. Don't fall for it. When a collector calls about old debt, ask them directly, "What is the date of first delinquency on this account?" They're required to tell you. If that date is beyond your state's statute of limitations, say these exact words: "I'm aware this debt is time-barred under my state's statute of limitations. I'm requesting you cease all collection activities and send me written verification that this account is closed." Then, follow up with a certified letter saying the same thing. You can do this. You have the legal right to stand up to these collectors. The law is on your side. Now, let's talk about the second bill you might not have to pay. And this one affects nearly every senior in America at some point. Medical bills. I want to be clear. I'm not saying you should never pay medical bills, but I am saying that hospital billing is so riddled with errors, inflated charges, and negotiable amounts that you should never accept the first bill you receive as the final word. Dorothy Martinez was 71 when she had emergency gallbladder surgery. She had Medicare, but the hospital billed her $18,000 for her portion. Dorothy looked at that number and felt her world collapse. She didn't have $18,000. She didn't have $5,000. She barely had $500 in savings. She started having panic attacks. Her blood pressure shot up. She couldn't sleep. Her son helped her do something simple but powerful. He called the hospital billing department and asked for an itemized bill. Not the summary bill with big category totals, but a line-by-line accounting of every single charge. When that itemized bill arrived, it was 14 pages long, and on those 14 pages were charges that made no sense. They'd billed her for 2 surgical procedures when she'd only had 1. They'd charged her for medications she'd never received. They'd listed equipment usage fees that were duplicated. There was a $300 charge for a blanket, a $150 charge for a box of tissues. When her son, who works in healthcare administration, reviewed every line, he found over $7,000 in errors and inflated charges. He wrote a formal dispute letter to the hospital. He referenced Medicare's allowable charges for each procedure. He pointed out the duplicate billings. He requested a complete audit of the charges. 6 weeks later, the hospital sent a revised bill, $6, $200. Still a large amount, but not the financial catastrophe of $18,000. Then he did something else. He called the billing department again and asked if Dorothy qualified for charity care. Most hospitals, especially nonprofit hospitals, are required to provide charity care or financial assistance to patients below certain income levels. Dorothy's only income was $400 a month in Social Security. She absolutely qualified. The hospital sent her a 2-page application. She provided proof of income, proof of assets, and a letter explaining her financial hardship. 8 weeks later, she received a letter stating her remaining balance had been forgiven entirely under the hospital's financial assistance program. Dorothy owed nothing. Let me give you the exact steps to fight medical bills. First, never ignore a medical bill, because ignoring it can lead to collections and credit damage. But don't pay it immediately either. Second, request an itemized bill within 30 days of receiving the summary bill. This is your legal right under federal law. Third, review every single line with a critical eye or have someone help you who understands medical billing. Look for duplicate charges, services you didn't receive, incorrect quantities, and charges that seem unreasonably high. Fourth, compare the charges against Medicare's allowable amounts for those procedures. You can find these online at the Medicare website. If the hospital is charging you double or triple what Medicare allows, that's a red flag. Fifth, write a formal dispute letter. Be specific. List each charge you're disputing and why. Request a complete review and adjustment. Sixth, ask about financial assistance programs. Every hospital that receives federal funding is required to have a financial assistance policy. They have to tell you about it if you ask. Don't be embarrassed. These programs exist for people exactly like you. Seventh, if the bill is still too high after adjustments, negotiate a payment plan with zero interest or ask for a settlement where you pay a reduced lump sum. I've seen hospitals accept 30 cents on the dollar for cash settlements, especially for older debts. You have more power than you think. Medical billing is not set in stone. It's negotiable, contestable, and often forgivable. You can do this. You deserve accurate billing and fair treatment. The third bill you might not legally have to pay is something called a deficiency balance after foreclosure. This is a bill that comes after the bank has already taken your home. Let me tell you about William Foster. William was 76 when he lost his home to foreclosure in 2019. He'd fallen behind on his mortgage after his wife passed away and medical bills piled up. The bank foreclosed, sold his house at auction for $150,000, but his remaining mortgage balance was $210,000. A few months after losing his home, William received a bill for $60,000, the deficiency balance. The bank was claiming he still owed the difference between what they sold the house for and what he owed on the mortgage. William was living in a small rental apartment on $600 a month in Social Security. He had no assets. He had no savings. The idea of owing 60 USD on top of losing his home sent him into a deep depression. What William didn't know was that in his state of California, lenders cannot pursue deficiency balances on primary residence foreclosures in certain circumstances. California has anti-deficiency laws that protect homeowners. If your home was your primary residence, and if it was a purchase money loan, meaning the original loan you used to buy the home, the lender cannot come after you for the deficiency. There are 12 states with strong anti-deficiency laws: Alaska, Arizona, California, Connecticut, Hawaii, Idaho, Minnesota, North Carolina, North Dakota, Oregon, Washington, and Wisconsin. Even in states without blanket anti-deficiency laws, there are often protections for specific types of loans or specific foreclosure processes. William consulted with a housing attorney who worked for a nonprofit legal aid organization. The consultation was free. The attorney reviewed his foreclosure documents and confirmed that under California law, the bank had no legal right to collect that $60,000 deficiency. The attorney wrote a cease and desist letter to the collection agency. The debt disappeared. William didn't owe it. He never owed it. But the bank hoped he didn't know his rights. If you've lost your home to foreclosure and you're receiving bills for deficiency balances, here's what you need to do. First, determine if your state has anti-deficiency laws. You can search for anti-deficiency laws plus your state name or contact a HUD-approved housing counseling agency for free guidance. Second, review your original loan documents. Was this the loan you used to purchase your home, or was it a refinance or home equity loan? That distinction matters in many states. Third, determine if the foreclosure was judicial, meaning through the courts, or non-judicial, meaning through a trustee sale. Some state protections only apply to one type or the other. Fourth, if you believe you're protected by anti-deficiency laws, send a written response to the creditor stating that the debt is not legally collectible under your state's anti-deficiency statutes. Cite the specific law if you can. Fifth, if the creditor continues to pursue collection, contact a consumer rights attorney or a legal aid organization. Many will take these cases for free or low cost because violations of anti-deficiency laws can result in penalties against the creditor. You are not powerless. Even after losing your home, you have legal protections against being financially destroyed by deficiency balances. You can do this. The law recognizes that foreclosure is punishment enough. Now let's talk about the fourth bill you might not have to pay, and this one surprises a lot of people. Gym memberships and subscription services you thought you canceled but keep getting billed for. I heard a case involving Sandra Peterson, who was 69 years old. She joined a gym in 2018, used it for about 6 months, then stopped going when she developed knee problems. She thought she'd canceled her membership. She called the gym, spoke to someone at the front desk, and was told she was all set. But the charges kept coming. $45 every month automatically deducted from her checking account. Sandra didn't notice at first because she wasn't checking her bank statements carefully. By the time she realized what was happening in 2021, the gym had taken $620 from her account for a membership she thought she'd canceled 3 years earlier. When she called the gym, they told her there was no record of her cancellation. They said she needed to have submitted written notice 30 days in advance, per the contract she signed. They refused to refund any money. Sandra felt helpless. She'd signed a contract. Surely that meant she was stuck. But here's what Sandra didn't know. The Federal Trade Commission has rules about subscription services and automatic renewals. Many states also have laws requiring clear cancellation procedures and prohibiting businesses from making cancellation unreasonably difficult. Sandra filed a complaint with her state's Attorney General Consumer Protection Division. She also disputed the charges with her bank under the Electronic Fund Transfer Act, which gives consumers the right to stop pre-authorized payments. She sent a certified letter to the gym formally revoking authorization for any future charges and demanding a refund of charges made after her verbal cancellation attempt. The bank reversed 12 months of charges, giving her back $540. The State Attorney General's office contacted the gym as part of an investigation into their cancellation practices. The gym, facing potential fines and legal action, refunded Sandra an additional $800 and canceled her membership with no further penalties. Sandra got back $340 of the money that had been taken from her. But more importantly, she learned that verbal cancellations followed by continued billing can be challenged. Contracts don't give businesses unlimited power to charge you forever, especially when they make cancellation difficult or ignore your cancellation attempts. If you're being charged for gym memberships, magazine subscriptions, streaming services, or any automatic billing you believe you canceled or no longer want, here's your action plan. First, check your credit card or bank statements for the past year. Identify every recurring charge. You might be surprised what you find. Second, for any service you want to cancel, send written notice via certified mail. Email is not enough because it's too easy for companies to claim they never received it. Your letter should say, "I am canceling my membership effective immediately. Do not charge my account again. I revoke authorization for any future automatic payments. Include your account number, name, and contact information." Third, simultaneously contact your bank or credit card company and revoke authorization for that merchant to charge your account. Under the Electronic Fund Transfer Act, you have the right to stop pre-authorized electronic payments. Fourth, if charges continue after you've revoked authorization, dispute them immediately with your bank. You typically have 60 days from the statement date to dispute unauthorized electronic transfers. Fifth, file a complaint with your state attorney general and the Federal Trade Commission if the company refuses to stop billing you. These complaints create a record and can trigger investigations into predatory business practices. Sixth, if you've been charged for months or years after attempting to cancel, demand a refund in writing. Reference your state's consumer protection laws and the FTC's rules on negative option marketing. Many companies will refund rather than face legal action. You are not trapped in subscriptions forever. You have the legal right to cancel, and you have recourse when companies ignore your cancellations. You can do this. Your money is yours, not theirs. The fifth bill you might not have to pay involves utility deposits when you move or start new service. I know this seems small compared to medical bills or mortgage deficiencies, but for seniors on fixed incomes, a $200 utility deposit can be the difference between eating well and skipping meals. I remember Clara Washington, 72 years old, who moved from her longtime home into a senior apartment after her husband died. The electric company demanded a $250 deposit to start service. Clara had always paid her utilities on time for 50 years. She had excellent credit. But the company had a blanket policy requiring deposits for all new customers in that zip code. Clara paid the deposit because she needed electricity, but it meant she couldn't afford her blood pressure medication that month. What Clara didn't know was that many states have laws protecting seniors and low-income individuals from utility deposits, or requiring utilities to waive deposits for customers with good payment history. In Clara's state of Illinois, utilities must waive deposits for customers over 65 who demonstrate financial hardship and agree to payment arrangements if needed. Clara qualified but was never informed of this option. After learning about the law from a legal aid clinic, Clara requested a review of the deposit requirement. She provided proof of her age, her prior payment history with her previous utility account, and her current income level. The utility company refunded her $250 deposit within 30 days. That money went straight to the medications she'd been rationing. Here's what you need to know about utility deposits. First, before paying a deposit, ask the utility company what their policy is for seniors, low-income customers, and customers with good payment history. Many have waiver programs but don't advertise them. Second, if you have documentation of on-time utility payments from your previous address, provide that. It can be grounds for waiving a deposit. Third, check your state's Public Utility Commission regulations. Many states have consumer protections that limit when utilities can require deposits and mandate alternatives like payment plans or smaller deposits for protected classes of customers. Fourth, if you're on a fixed income, specifically ask about low-income assistance programs. Many utilities have programs that not only waive deposits, but also provide monthly billing discounts for qualifying seniors. Fifth, if a utility has already collected a deposit and you've now established 12 months of on-time payments, request a refund of your deposit. Most state laws require utilities to return deposits with interest after you've proven reliable payment. If the utility refuses to waive a deposit you believe should be waived under your state's laws, file a complaint with your state's Public Utility Commission. These agencies have enforcement power over utilities and take consumer complaints seriously. Don't assume you have to pay every fee or deposit a company demands. Many are negotiable, waivable, or outright illegal when applied to seniors or low-income customers. You can do this. Utility companies are regulated, and those regulations are designed to protect vulnerable customers like you. The sixth bill you are absolutely not required to pay, and this one is critical, is debt from a deceased spouse that was solely in their name. This is one of the most common ways predators exploit grieving seniors. Let me tell you about Helen Brooks. Helen was 74 when her husband James passed away from cancer. 3 weeks after his funeral, while Helen was still processing her grief, she started getting calls from creditors. James had racked up $35,000 in credit card debt during his final year of life, mostly medical expenses that insurance didn't cover. The creditors called Helen daily. They told her she was responsible for her husband's debts. They said it was her legal obligation as his widow. They threatened to put liens on her home. They said her credit would be destroyed if she didn't pay. Helen was terrified and overwhelmed. She set up payment plans she couldn't afford. She drained $8,000 from her savings in the first 4 months trying to pay James's creditors. She was headed toward financial ruin, trying to honor what she thought was her legal duty to pay her deceased husband's bills. But here's the truth that those creditors didn't tell Helen. In most cases, you are not responsible for your spouse's individual debt after they die. If the credit card was solely in your spouse's name, if the loan was only their signature, if you were not a co-signer or joint account holder, you typically do not inherit that debt. The debt must be paid from the deceased person's estate, meaning their assets, before those assets can be distributed to heirs. But if the estate has insufficient assets to cover the debts, the creditors are out of luck. The debt dies with the person. Community property states have different rules, and you should consult an attorney if you live in Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, or Wisconsin. But even in community property states, there are significant protections for surviving spouses. Helen finally consulted with an elder law attorney. The consultation cost $100 but saved her from financial catastrophe. The attorney reviewed all of James's debts and Helen's financial situation. None of the credit cards were in Helen's name. She had not co-signed any of the accounts. James's estate consisted of a paid-off car worth about $3,000 and $200 in a checking account. That was it. The attorney wrote letters to all the creditors explaining that Helen was not legally liable for the debts, that James's estate had minimal assets, and that all collection efforts directed at Helen must cease immediately. The attorney also reported the creditors to the Federal Trade Commission for violations of the Fair Debt Collection Practices Act, which prohibits misrepresenting the legal status of debts and harassing consumers. The calls stopped. The collection letters stopped. Helen didn't owe a penny of her husband's debt. If you've lost a spouse and creditors are contacting you about their debts, follow these steps carefully. First, do not make any payments on debts that were solely in your spouse's name. Making even one payment can be interpreted as accepting responsibility for the debt. Second, request written verification of every debt. The creditor must prove the debt exists and must clarify whether you were a co-signer or joint account holder. Third, review your state's laws on spousal debt responsibility. In most common law property states, you're not responsible for your spouse's individual debts. Fourth, if creditors continue contacting you after you've informed them the debt was not jointly held, document every contact. Save every letter, record the date and time of every phone call, and note what was said. This documentation can be used to file complaints and potentially take legal action against abusive creditors. Fifth, consider consulting with an estate attorney or elder law attorney. Many offer free or low-cost initial consultations. They can review your specific situation and send cease and desist letters to creditors on your behalf. Sixth, if you're being harassed or threatened by creditors over your deceased spouse's debts, file complaints with the Consumer Financial Protection Bureau and the Federal Trade Commission. These agencies have the power to investigate and punish creditors who violate debt collection laws. Know this: grieving the loss of your spouse is hard enough. You should not have to sacrifice your financial security to pay debts that are not legally yours. The law protects you. Creditors are counting on you, not knowing that. You can do this. You can stand up to these creditors and protect what's yours. The seventh and final bill you might not have to pay is magazine subscriptions, book clubs, and other mail order scams that you never authorized, or that continue billing you despite cancellation attempts. I saw a case with Thomas Riley, 78 years old, who discovered he was being charged $29.99 every month for a magazine subscription he didn't remember ordering. When he investigated, he found he'd checked a box on a sweepstakes entry form 3 years earlier. That box, in tiny print, enrolled him in an automatic subscription renewal program. Over 3 years, he'd paid nearly $100 for magazines he mostly threw away. When Thomas tried to cancel, he called the number on his credit card statement. He was transferred 5 times, put on hold for 45 minutes, and finally told he needed to write a letter to an address in Delaware. He wrote the letter. The charges continued. He wrote another letter, this time certified mail with return receipt. The charges continued. The company kept billing him, claiming they had no record of his cancellation requests. Thomas felt powerless against this faceless corporation, but he had more power than he realized. Under the FTC's telemarketing sales rule and most state consumer protection laws, companies that use negative option marketing, where your silence or failure to cancel is treated as agreement to keep paying, must provide simple cancellation mechanisms. Thomas filed a complaint with the Federal Trade Commission and his state attorney general. He also disputed 12 months of charges with his credit card company, claiming the charges were unauthorized because his cancellation requests had been ignored. The credit card company investigated and reversed $360 in charges. The FTC complaint triggered an investigation into the company's practices. It turned out Thomas wasn't alone. Thousands of seniors had similar complaints. The company eventually settled with the FTC, agreed to change their practices, and issued refunds to affected consumers. Thomas received a settlement check for $740, covering most of what he'd been improperly charged. If you're dealing with subscription scams or unwanted recurring charges, here's how to fight back. First, review all your credit card and bank statements for recurring charges you don't recognize or no longer want. These charges often have vague company names that don't clearly indicate what they're for. Second, contact your credit card company or bank and dispute the charges. Explain that you canceled the service or never authorized it in the first place. Under the Fair Credit Billing Act, you have the right to dispute billing errors, which includes charges for goods or services you didn't accept or that weren't delivered as agreed. Third, send a written cancellation notice to the company via certified mail. State clearly, I did not authorize these charges and I demand immediate cancellation of any subscription or membership associated with my account. Stop billing me immediately. Fourth, simultaneously, send a letter to your credit card company revoking authorization for that merchant to charge your card. This is a separate step from disputing past charges. You're preventing future charges. Fifth, if the company claims you're in a contract and threatens penalties for early cancellation, research your state's laws on unfair business practices. Many states prohibit automatic renewal contracts that weren't clearly disclosed or require easy cancellation options. Sixth, file complaints with the FTC, your state attorney general, and the Better Business Bureau. Your complaint becomes part of a pattern that regulators use to identify and prosecute bad actors. Seventh, if you're elderly or disabled, mention this in your complaints and in your correspondence with the company. Many state laws provide additional protections for seniors against deceptive practices. Don't be embarrassed if you've been caught in a subscription scam. These companies design their marketing and cancellation processes to be confusing, specifically to trap people. You're not alone, and you have legal tools to fight back. You can do this. You can stop these charges and get your money back. Now, let me bring this all together for you. We've covered 7 types of bills that you might not be legally required to pay. Time-barred credit card debt that's too old for creditors to sue you over. Medical bills that are inflated, inaccurate, or subject to charity care programs. Deficiency balances after foreclosure in states with anti-deficiency laws. Gym memberships and subscriptions you canceled, but that keep billing you. Utility deposits that should be waived for seniors with good payment history. Debts from your deceased spouse that were solely in their name, and magazine subscriptions or mail order scams you never authorized. Each of these situations has happened to real seniors I've encountered in my 32 years as a judge. Each of these seniors felt powerless at first. They believed they had no choice but to pay. They were afraid of legal consequences, credit damage, or moral judgment. But once they learned their rights and took action, they saved thousands of dollars and reclaimed their financial dignity. I want you to understand something important. Creditors and collection agencies rely on fear and ignorance. They use legal-sounding language to intimidate you. They imply consequences that aren't real. They pressure you to pay immediately without giving you time to research your rights or seek help. This is intentional. They know that informed consumers are empowered consumers who don't pay debts they don't legally owe. But you're informed now. You know your rights. You know the strategies to fight back. You know where to find help. The question is, will you use this information? Let me give you some practical next steps. First, gather all your bills and financial statements. Make a list of every debt or recurring charge you're currently paying. For each one, ask yourself, do I know what this is for? Do I remember authorizing this? Is this something I still need or use? Am I being charged the right amount? Second, for any debt on your list that's more than 3 years old, research your state's statute of limitations on that type of debt. If the statute has expired, that debt may be time-barred and unenforceable. Third, for any medical bill over $500, Request an itemized statement and review it carefully for errors. Then ask about financial assistance programs. Fourth, if you've lost your home to foreclosure and you're receiving deficiency balance bills, research your state's anti-deficiency laws or contact a SHUD-approved housing counselor. Fifth, review your bank statements for recurring subscription charges. If you find any you don't want, follow the cancellation process I outlined earlier. Sixth, if you're widowed and being contacted about your deceased spouse's debts, do not pay anything until you've confirmed in writing that you were a co-signer or joint account holder on that specific debt. Seventh, if creditors are harassing you, threatening you, or misrepresenting your legal obligations, document everything and file complaints with the appropriate authorities. I also want to encourage you to seek help when you need it. You don't have to fight these battles alone. There are free resources available to you. Legal aid organizations in every state provide free legal assistance to seniors and low-income individuals. You can find your local legal aid office by searching online or calling the National Legal Services Corporation hotline. The National Council on Aging has a benefits checkup tool that can help you identify programs you qualify for, including utility assistance, prescription drug assistance, and financial counseling. RP offers free financial resources and can connect you with elder law attorneys. Your local area agency on aging provides services and advocacy for seniors, including help navigating financial issues. State Attorney General offices have consumer protection divisions that investigate and take action against companies that prey on seniors. The Consumer Financial Protection Bureau has an entire office dedicated to helping older Americans with financial issues. You can submit complaints online or call their hotline. Don't suffer in silence. Don't drain your savings paying bills you don't legally owe. Don't sacrifice your quality of life because a creditor is pressuring you. I've seen too many seniors go without medication, skip meals, or live in constant anxiety because they're paying debts they're not responsible for. I've also seen seniors reclaim their financial independence once they learned their rights and took action. You deserve to live your retirement years with dignity and financial security. The money you've saved throughout your life should support you now, not be handed over to creditors exploiting your lack of legal knowledge. Remember Margaret Thompson from the beginning? After she learned about time-barred debt, she stopped making payments on that old credit card. She sent a cease and desist letter. The call stopped. She kept her money. With the $200 a month she was no longer paying, she was able to afford better food, keep up with her medications, and even save a little for emergencies. Her blood pressure went down. She slept better. She felt like she had control of her life again. That's what knowing your rights can do. It's not just about money. It's about dignity, peace of mind, and the ability to live without fear. You've worked hard your entire life. You've paid your taxes, raised your families, contributed to your communities. You deserve to enjoy your senior years without being financially exploited. Before I close, I want to address something I hear often from seniors. But shouldn't I pay my debts? Isn't it wrong not to pay what I owe? I understand that concern. Most of you were raised with strong values about financial responsibility and keeping your word. Those are good values. But here's what I want you to understand. There's a difference between a moral obligation and a legal obligation. If you borrowed money and you're able to pay it back, of course you should. But if a debt is time-barred, that means society, through its laws, has decided that the creditor waited too long to collect. The legal system has said that debt is no longer enforceable. That's not you being irresponsible. That's the law protecting you from indefinite financial liability. If a hospital overbills you by thousands of dollars through errors and inflated charges, you're not morally obligated to pay for services you didn't receive or charges that violate Medicare guidelines. You're protecting yourself from fraud. If a company continues to charge you for a subscription you canceled, or if creditors claim you're responsible for your deceased spouse's individual debts when the law says you're not, standing up for yourself isn't wrong. It's necessary. The companies and creditors we've discussed today are not charities, they're businesses. Many of them specifically target seniors because they know older Americans tend to be trusting, conflict-averse, and unaware of their legal protections. They count on your good values to take advantage of you. Fighting back against exploitation isn't unethical. It's self-defense. So I'm asking you to let go of any guilt or shame you might feel about asserting your rights. You're not being difficult. You're not being cheap. You're being smart. You're protecting the financial security you worked decades to build. Now, here's what I need you to do after watching this. First, take action on at least one bill or debt situation in your own life within the next 7 days. Pick the one that's costing you the most money or causing you the most stress and take the first step toward addressing it. That might be requesting an itemized medical bill, researching your state's statute of limitations, or sending a cancellation letter for an unwanted subscription. Second, share this information with other seniors you know, your friends, your siblings, your neighbors, people at your church or community center. Financial predators are targeting all of us. The more people who know their rights, the harder it becomes for these companies to exploit our community. Third, if this information helped you, or if you have questions, or if you have a success story about standing up to a creditor, leave a comment below. Your engagement helps this video reach more people who need it. And I read the comments. If there's enough interest, I'll make follow-up videos diving deeper into specific issues. Fourth, click that like button and subscribe to this channel. I'm going to continue sharing legal information that protects seniors from financial exploitation. You deserve to have someone in your corner who understands the law and cares about your well-being. You are not powerless. You are not alone. You have rights, you have resources, and now you have knowledge. Use them. Stand up for yourself. Protect your financial security. You've earned it. Go forward with confidence, knowing that the law is on your side. You can do this. I believe in you.